or 8,000 years ago, they laid down the law. 6 or 8,000 years ago, they laid down the law.
Welcome everyone. I hope you enjoy this audio PowerPoint lecture. But let me first of all start with, what on earth with that music? Well, that's the B-52s, famous for their hit Rock Lobster, and another song called Mesopotamia. They talked about the beginning of law, and quite frankly, if you haven't guessed it yet, that's Hammurabi, and he's handing out the code of Hammurabi, the first known printed in cuneiform, printed legal system. So way back in Mesopotamia. So don't say you've never heard a song about Mesopotamia and the law. So you have, and you probably regret it. Anyway, let's get going on the audio lecture. And let's first of all start to talk about other rules of conduct that are law-like without being law. Now, we know these, we practice these, even though we never thought of them perhaps as being law-like, but clearly they are. For instance, many laws trace back to morals and our moral system. Thou shalt not kill is a moral edict as well as a law. So one shouldn't be surprised that many of our laws are reflected in our morals, and many of our morals are reflected in law. Second, etiquette. I don't know if you've ever gone to a fancy dinner with, 6 forks and 2 knives and little bowls and plates and God only knows how many spoons and the like. And I'm not sure what your table manners were like, but I couldn't figure out half the instruments, and especially when they presented me with a small bowl of warm lemon water at the beginning. I thought that was to clean my palate. I didn't realize it was actually to clean my fingers. So, and I drank it. So, anyway, I'm a hick. So, etiquette, or, keeping a door open when somebody is right behind you, is etiquette. And you'll notice that, depending on the circumstance, you might hold the door open quite a long time. If the person behind you might be elderly or struggling with the box, or, in some other way limited, physically, you might be much more attentive to their needs. than another student who, was talking with you and is a good buddy of yours, and you don't have to hold open for them. You just basically pull the door open and make sure it doesn't spring back in their face. All sorts of contractual behavior. We behave law-like because of contracts that we enter into, either formal or informal. Think of the rules of conduct, like at West Point or our other military academies. If you cheat, you violated a rule of conduct. You violated the laws of West Point. But more so, if you know of another who has cheated and you don't report that person, you've cheated. You take on the mistakes of others. And finally, games, athletic events, recipes. These are all law-like without being law. 3 strikes and you're out. 4 balls and you walk. Point after kick is worth 1, while a field goal is worth 3. Recipes, which are not necessarily followed in Clay Hall, but a 3-egg omelet is an omelet where you crack 3 eggs, and the like. These are all law-like rules without being law. So you notice our lives are really quite dominated by, obviously, the law, but other forms of moral, etiquette, contractual behaviors, and the games we play, the athletic events, and the recipes we follow. We follow things throughout our lives that are restrictive, like law, without being law. Now, if I haven't warned everybody, I should warn you all, it's almost too late now, that every political science course, even the legal ones, have to begin with Aristotle. So, Aristotle. In fact, we're going to be combining Socrates, Plato, and Aristotle together when we talk about the ancient or Greek concept of the law. Now, obviously we could do this because this is not a course in philosophy. At best, it's a mini course in legal philosophy. And quite frankly, lawyers, when they could shrink things into easier understood concepts, they'll do so. Socrates and Plato and Aristotle were all talking about the concept of virtue. Now, we have taken this word virtue and turned it into a very good thing. Well, Socrates, Plato, and Aristotle did not have this singular viewpoint of what virtue is. To them, virtue is the good of a person or a thing. In other words, a person or thing improve themselves, perfect themselves or itself, either through virtuous deeds or heroic acts, or better ones come along. The concept of virtue is almost like a social Darwinistic concept, the evolution towards better forms, more adaptive forms. So virtue is the idea that all individuals, all society, and quite frankly all things, are hopefully evolving towards its virtuous state. And one evidence of this is in the political animal, what they called humans, the political animal. It's the only animal that they saw that lives in groups that are able to live together by speech alone. Not by force, not by instinct, but by speech. And they called this organization, the city-state, on the larger scale, they called it the polis. P-O-L-I-S, the polis. Where we get, words like metropolitan, okay, or police, polis, P-O-L-I-S. That words alone can bring people together to form a group. Now, we also see this in the self-imposed death sentence of Socrates. He was found guilty of corrupting the youth, and he had a choice. Either he could exile himself to a different city-state than Athens, or he could drink the hemlock and die. And he was so committed to this concept of the evolution towards better forms and better city-states that he chose to die in Athens rather than to continue to live in a different city-state. For him, Athens was the most evolved, the most civilized, that's a weighted term, the most civilized city-state. It was far better than Sparta. Sparta was very good. It was very militaristic and had order, but it didn't have what he called democracy. It was better than thieves. It was better than, and we even use this term today, Crete, the Cretans. When you say someone's a Cretan, you're saying that they're not really as evolved as you. Oh, they're such a Cretan. And, you know, other city-states like Troy, the Trojans, or the Persians. Now, there were many different city-states in other countries that were not evolved as the Greeks, at least as the Greeks saw themselves. And they called these individuals Baba, or Barber, or barbarians, because to them, those political animals were babblers. They didn't make sense. Their words did not make sense because they weren't speaking Greek. Thus, they were babblers. They were uncivilized. Now, the political life of the city-state, or polis, surrounded the deliberation of the laws. The human, Socrates, Plato, and Aristotle argued, could perfect him or herself, actually himself, because it was a sexist society. The human could perfect himself through his active participation, through speech, and in legal formation in the polis. In turn, the polis would be perfected, thus raising better citizens. Better citizens meant a better city-state, or polis. A better polis meant better citizens, and on and on and on. The other thing we could do in this course is that we could jump forward thousands of years, and I'll do so to the period known as the Renaissance. Here we find three very important legal philosophers. One was Thomas Hobbes, the gentleman in the upper right, and the second one was John Locke. And Hobbes and Locke and Rousseau, our third, came up with the concept of the state of nature and the concept of natural law. Hobbes was trying to prove whether man could create government without relying on God. Now, Hobbes did not say there is no God. He said, assume there is no God. Can we get to government and laws without the imposition of a God figure? And the reason why he was making this argument is you have to remember the time in which these individuals were writing. They were writing in the end of the Dark Ages, the end or the beginning of the Renaissance, the rebirth. Okay? And during this period of time, many of the rulers depended on their rule, or their source of their rule was some reference to God. God made me king. God made me dictator, and the like. Now, what he was trying at, and it was revolutionary for its time, and was this idea that you don't have to rely on a God figure to argue for the rationale of creating government and the law. Now, even in this state of nature, where there are no laws, there are no governments, he said that there were still two types of rules. The first of these, he named instrumental rules. These are goal-oriented rules. You want to bring about a specific goal. You want to bring about a specific result. A recipe, for example. What must you do to create the 3-egg omelet? You must crack 3 eggs. What must you do to get a base on ball? Or a base on balls, I should say. Well, you have to stand there and hopefully the pitcher will cooperate and throw 4 balls. Thus that way you get to first base, a base on balls. So instrumental rules are goal-oriented to achieve a specific goal or specific result. The other set of rules he calls categorical rules. These are rules from which a plea of self-interest is not allowed. Thou shalt not kill is a categorical rule. Notice you cannot plead self-interest. Or you can go back to sports. 3 strikes and you're out. So if you have a forced strike, you're not playing baseball anymore. You understand? The categorical rule would negate the circumstance you currently think you have. Now, this does not account for Pee-wee ball. God forbid if any of you had to endure through that. Having 16 nieces and nephews, I had endured through many Pee-wee ball games where no one keeps count and there's no balls and no strikes and everyone's doing a great job. That made me sick. But in categorical rules, I was having a flashback there, people. In categorical rules, you follow them because you have no choice. You must follow them. For instance, morals are premised on categorical rules. Thou shalt not kill is a moral rule. And like I said prior, a plea of self-interest is not permitted. Even if self-interest would serve you better. Why can't I kill? You know, I would be in a better situation if I could kill. In some circumstances, perhaps. And like I said, morals fall under this category. Now, think about all the informal legal principles that we follow. All of these, for instance, a legal document like a will or a trust or contract or a deed, you can't plead self-interest alone. You cannot alleviate yourself from the duties or obligations of a contract. Equally, your morality, you can't alleviate yourself from the care of a child or an elderly person. So we have a blend, if you will, during this period of time of the formal legal rules and informal legal principles. Now, what's important about these individuals? They're important for two reasons. One, they're a departure from the natural law thinkers. Okay? A law can be premised on, of all things, human reason. Think of our own documents, and that's what I want to get to secondly. These individuals, Thomas Hobbes, John Locke, Jean-Jacques Rousseau, are important thinkers of their day, and they're also the bedrock of the thinking that our forefathers, our scripters of our Constitution and legal order, were reading at the time that they were writing. Jefferson, Madison, Washington, all of the quote-unquote great founding fathers were reading Thomas Hobbes, John Locke, and Jean-Jacques Rousseau. It was part of their basic classical education. And you'll notice that many of the documents they wrote are premised on this departure. For instance, we hold these truths to be self-evident, that all men are created equal. Self-evident. What on earth does that mean? Self-evident means that you don't have to be told it in a scripture or in a Bible. They're self-evident. All you need to do is use human reason to discern. Understand? So when King George III did what he did to us colonists, and there was a petition in the form of the Declaration of Independence, it was a plea to human reason. We hold these truths to be self-evident. It's a plea to human reason. Not to the God told us we must break away from Britain. It wasn't God, it was basic human reason. And this is key behind the meanings of natural law and natural rights. You have a right from nature. You're born with certain rights. And these rights we call natural rights or human rights. To preserve oneself is a law of nature. You're born with the idea of preserving yourself. Every human being has this natural right. Now, this is quite different than civil rights. Civil rights are rights that are given to you by government. If government gives them to you, government can take them away. If government interferes with a natural right, government is at wrong. You understand? Well, it's not good asking rhetorical questions during an audio lecture, but I hope you understand this point. Natural rights, government cannot interfere with. Civil rights, they give them to you, government, or they can take them away. But what's key here, I know what many of you are probably thinking. What about execution? Well, one argument that a reasonable or rational school thought person like Hobbes, Locke, and Rousseau would argue is capital punishment is typically meted out if you have taken away the natural rights of another. You kill someone else, your natural right to life is now vanquished. It's now vacant. And what government is doing is merely following on, reestablishing the order, if you will. Now, what do we call these rights? We call them inalienable, the ones that come from natural law. They don't come from a document. They're not positive law that government created. And we call the rights that come from them inalienable. You've seen this word in many of our documents. The inalienable right to life, liberty, and remember that bastardization, pursuit of happiness. The inalienable rights, or the fundamental rights, are life, liberty, property. That's what Hobbes, Locke, and Rousseau were writing about. It's our founding fathers that bastardized them. Said life, liberty, and the pursuit of happiness. Okay? So, inalienable rights come from natural law. Fundamental rights are inalienable rights. They're both the same. Now, Locke basically added again the concept of the God figure. God as a final enforcer of the law. His argument was, and it was an addition, if you will, to Hobbes, that if you take the natural law system of nature and Hobbes' state of nature, where there are no laws, no government, and you create laws and government through human reason, if you add God back and these same individuals fear God, to Locke you have a civil society. So he adds the concept of the civil society to Hobbes' natural law structure. So here's your first math of the course. God plus Hobbes equals Locke. Or Locke minus God equals Hobbes. But they're writing basically in the same genre, if you will, the same philosophical background. Now we're going to jump another 300 years and come up to the modern concept of the law, known as legal positivism. Now, legal positivism became very popular in the late 19th century and early 20th century. The quote-unquote father of modern legal positivism is a gentleman in the upper right there, John Austin. He wrote a book in 1832 titled The Province of Jurisprudence Determined. And he basically makes the following standard. Law is the command of a sovereign. The command is the will of the sovereign backed up by the threat or use of a sanction. So law is merely what the sovereign sanctions. Let me say that a different way. Laws that are not enforced are not laws. Because laws to be laws must be backed up by the threat or use of a sanction. Now, anybody who's driven on any of the interstates will tell you that traffic laws are not laws. And according to John Austin, they'd be right. What is the speed limit? 55. What is the actual speed limit? If you ask a driver, 62. It's the magical 7-mile-an-hour edition. Right? 65. Oh, that's 72. North Carolina has 70. I don't know if it goes up to 80. I'm not sure. But you understand that, you know, not using your blinker before changing lanes, or not signaling when you're about to take an exit, and all these other infractions that you see on a daily basis would put into severe criticism the idea that we have traffic laws. I know driving to campus, I probably break 3 or 4 of them on the way. And anyone else who could say that they don't is in fact a liar. So law is law is if it's backed up by a threat or use of a sanction. Okay? Now, what does this make law then? Well, it makes it an empirical inquiry. Instead of a rational inquiry as to what human reason would discern, or the earlier natural law of just, it should be correct, it should be virtuous, it should help improve you or society, the positivists make the inquiry into law merely an empirical inquiry. Is it a law? Well, is it enforced? If the answer is yes, it's a law. If the answer is no, it's not a law. So the great virtue, I'm sorry to use that term virtue, of this whole notion of legal positivism, it's its utter simplicity. Law is law if it's enforced. If it's not enforced, it's not the law. So there goes the, the questionable legal decisions that we've seen courts render in the past. 25 to life to someone who's a domestic terrorist at the age of 15 who uttered some words in a video game, or if the glove don't fit, you must be quit, right? It adds the idea, like years ago I used to, this is a common adage, if you don't want to do the time, don't do the crime. I changed all of that. I'd say now, don't worry about doing time if you committed the crime, if you got the dime. Because we see that the rich are meted out justice under the law differently than the poor. Now, some of you might refute that, and some of you thus are wrong. But I say that tongue-in-cheek, but I'm actually serious. You see a different standard. You commit a crime and you're rich, you go to Club Fed, you're released at weekends, you have your own suite, you get your own cook, and if you're poor with bad legal representation, you go to ass-pounding penitentiary. Okay? And I don't have to go into that anymore, because I think we've all seen it when you said, how on earth did that person get off? Now, the other virtue, excuse the pun, is that it's quite different than natural law theorists, the Locke, Hobbes, and Rousseau, and the one taken up by the Catholic Church and such philosophers as St. Augustine. St. Augustine was to state many years before that an unjust law is not a law at all. An unjust law is not a law at all. Now, what happens about the law of a dictator? According to legal positivists, they're laws. You don't make any moral inquiry. It's merely an empirical one. So in Saddam Hussein's Iraq, who was the law? He was. How do you know? Doubt it, you're dead. Right? It makes dictatorships incredibly efficient little organizations. Okay? Is what he did correct? Legally? A moralist or naturalist or even a rational theorist like Hobbes, Locke, and Rousseau would say, no, it's not correct. Positivists would say, were his laws enforced? Answer yes, then it's law. Now, one case I want to talk to you about that's not in your book is an early case known as Riggs versus Palmer. It comes to us from Massachusetts around 1922, and it points out the problem of when laws in the books are not sufficient to cover immorality. Riggs or Palmer, I can't remember which one, it doesn't matter, was a rich kid. He was rich because his grandfather used to give him lots of money. And he was on a week by week allowance. And he was in his, late teens, early 20s. And he wanted to get all the money because he was having a hell of a good time in the roaring 20s. So to him, the fastest way to get to all the money was to kill his grandfather. And he did. And he thought he was the virtuous criminal, the perfect criminal. And we know he's not because we have a case known as Riggs versus Palmer. Okay? So the judge in Massachusetts goes to the legal tomes, he looks at the legal books, and lo and behold, it doesn't say anything about a person who kills the will holder shouldn't benefit from the will. It doesn't say that. Now, you and I rationally would say a person shouldn't benefit from their crime. especially the person that was due to inherit, shouldn't inherit faster because he killed the person from whom he was going to inherit. I mean, it makes sense, right? It's reasonable. And beyond all that, it's immoral otherwise. Well, the Massachusetts judge had a problem because there was nothing in the books that said that this bastard couldn't inherit after killing his grandfather. So he went to other legal systems. And he's allowed to do that. He's allowed to reach out to clarify the law. And he looked at other New England jurisdictions that have the old system of English common law. He looked to New York, he looked to Virginia, because they were rich, in Pennsylvania, were rich in legal traditions like Massachusetts was. He reached out to everywhere and there was nothing on the books. So he looked out to Britain. Since many of our laws come from English common law, he looked there. Nothing. So he was in a quandary. He knew what the decision should be, but he was limited by what the law was. Finally, he made the quote-unquote right decision and said, damn the law, morality and rationality dictate that this person shouldn't benefit from their crime. Now, you could say, oh, that's an old case. Well, Bernie Goetz decided that he was going to kill people on a Long Island subway, quite a few people, and in self-defense by shooting them in the back. Okay, there's a problem right there. Self-defense to a fleeing felon. Not so much, right? Well, he didn't mind doing the jail time, and he got some jail time for killing these young people because he was going to make out like a bandit on the book he was going to sell. And until the Bernie Goetz case in New York, you could profit from any book, publication, interview, whatever. And of course, you know, we have the crap journalists out there wanting to make a buck by interviewing bastards like Bernie Goetz. Well, the court ordered that not only couldn't he collect, that all of the monies, if he did publish a book, should go to his victims' families. Okay? And this set a precedent that many jurisdictions now have, that you cannot profit from your crime. Sounds great, right? Well, you got to wonder about the ones who steal millions and billions of dollars and after 10 years walk away with the profits. So, any case. Now, finally, that gentleman that looks like somebody from The Sopranos, it looks like the uncle, lower right, that gentleman's named H.L.A. Hart. And he was a follower, if you will, or he was the modern day version of John Austin. He said that the positivists can discern two types of rules: the primary rules and the secondary rules. The primary rules are quite like the laws that we know, like criminal law, like traffic law. Any law that imposes an obligation is a primary law, or excuse me, primary rule. But there was a second group, and a very small group of rules that confer power on a certain class of people who will make the primary rules. And that area of modern day law is constitutional law. What is constitutional law all about? It's not really about primary rules. It's not really about the obligations of law. It's more about who will make the primary rules, who will set the obligations, who will determine who should make the law. So H.L.A. Hart distinguishes between primary rules, what we know as law, traffic law, criminal law, property law, standards, obligations, and secondary rules, a set of secondary rules like constitutional law, to determine who should make those primary rules. Should it be the legislature? Could it be the president? Should it be a city council? Should it be a state? Should it be the federal government? The final argument that he makes, and a quite a good one, is that law in the legal system is the only compulsory association. He makes the argument that we're not obligated to any other association except the legal one. Think about Famika Kimura. Was she obligated to follow the law? The answer is yes. Even if she was utterly ignorant of it, even if she couldn't pronounce law, it doesn't matter. Ignorance of the law is no defense. When she stepped upon U.S. territory, whether it be the airplane or onto our property, onto our territory, she was obligated to follow the law.